this has not been into any of the question papers, so that we know that this topic in itself is not that important. However, we need to know about this because we can use all of these types in our answers, and we also cannot neglect it just because we haven't been asked any questions from this. So let's continue with writs, its types and its scope, which is under the chapter Fundamental Rights in Indian Polity. See, this writs has types. Types has what? See, first is habeas corpus, second is mandamus, third is prohibition, certiorari, QuoWarranto, and we are done. So this is the writs types. And then we have scope also. Let's see what is the scope and where all can the writs be used and what is its utility, how much can it go further in its existence. See, the Supreme Court under Article 32. What is 32? Right to constitutional remedies. We just studied in our last video that Article 32 is right to constitutional remedies. So Supreme Court under Article 32 and the High Courts under Article 226. So the same power here can issue the writs of habeas corpus, mandamus, prohibition, certiorari and QuoWarranto. Parliament can empower any other court to issue these writs. So this is important that under Article 32, not just Supreme Court, Parliament can empower any other court to issue these writs. Since no such provision has been made so far, only Supreme Court and High Court can issue writs and not any other court. Before 1950, only High Courts of Calcutta, Bombay and Madras had the power to issue the writs. So this is important. How? See, if a question asks, UPSC has been following this pattern, that if this is here, they can ask you whether writs can be writs issued by all the courts was in this constitution since the starts. This has been a pattern of UPSC, not over this question but other questions it has asked this way. So we need to know that no, initially it was only High Courts of Calcutta, Bombay and Madras that had the power to issue the writs, and Article 226 now empowers all the High Courts. So this is first paragraph, this is the scope. Next, writs are borrowed from English law where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king, who was and is still described as the fountain of justice. And later, High Court started issuing these writs as extraordinary remedies to uphold the rights and liberties of the British people. So, writ of jurisdiction of the Supreme Court differs from that of a High Court in three respects. 1, 2, 3. What are those three? Let's quickly go through them. See, Supreme Court can issue writs, High Court can issue writs, but Supreme Court can only issue writs during the fundamental rights. When fundamental rights have to be enforced, Supreme Court can issue writs. But High Court can issue writs not only for fundamental rights, that it can, apart from that, it can also issue writs for other purposes. So this expression shows that the writ jurisdiction of the Supreme Court is narrower than that of the High Court. The High Court's jurisdiction is wider than that of the Supreme Court here. Then Supreme Court can issue writs against a person or government throughout the territory of India. So Supreme Court can do it throughout the territory, but High Court can issue writs only of their location. If this is High Court of Madras, High Court can issue only here. So can issue writs against a person residing or against a government or territory located within its territorial jurisdiction, and outside only if the cause of action arises within its territorial jurisdiction. Thus, territorial jurisdiction of the Supreme Court is wider. So, writ jurisdiction is wider for High Court, but territorial jurisdiction is wider for the Supreme Court. And then a remedy under Article 32 is in itself a fundamental right, and hence Supreme Court may not refuse to exercise its writ jurisdiction. On the other hand, High Court may refuse to exercise its writ jurisdiction. So, Supreme Court is thus constituted as a defender, guarantor of the fundamental right. Thus, we will proceed to understand the meaning and scope of different kinds of writs mentioned in Articles 32 and 226 when we read about the types of the jurisdiction. So, what are the three differences? The first is Supreme Court can only issue for the fundamental rights, High Courts for other cases also. So, writ jurisdiction is narrower for the Supreme Court. Then, territorial jurisdiction is wider for the Supreme Court. Why? Because this can do throughout India, this only for their territory. And the third is that Supreme Court cannot refuse and High Court may refuse to exercise its writ jurisdiction. So, these are the three differences. And now we move on to the habeas corpus. See, the Latin term to have the body of. So, what happens in this is, see, an order is issued by the court to a person who has been detained another person to produce the body of the latter before it. The court, what does it do? It examines the cause and legality of detention. It would set the detained person free if the detention is found to be illegal. What is this writ? It is a bulwark of individual liberty against arbitrary detention. So when we are writing Article 22, we studied in our last video, it grants protection to persons who are arrested or detained. Here we can use habeas corpus as our example. So this is how we need to link our topics to each other for a perfect answer to come up. So what is this habeas corpus? It is for detained persons. What do? That detained person is showed in front of the Supreme Court, and then if the detention is found to be illegal, they can be freed. And thus this writ is a bulwark of individual liberty against arbitrary detention, and writ of habeas corpus can be issued against the public authorities as well as the private individual. However, it is not issued when the detention is lawful. With law, the detention has been done, or the proceeding is for contempt of a legislature or a court. See, contempt of court and contempt for legislature is a very big thing that has done. This again is divided into civil contempt and the criminal contempt. This we would go through when we study the contempt of court portion. So here writ of habeas corpus issued against this and this. Writ on the other hand is not issued where detention is lawful, contempt of a legislature or a court, and detention is by a competent court, and detention is outside the jurisdiction of the court. That is military detention. So this is habeas corpus. It is issued against the detained person, cannot be issued in these 4 cases, and we can link this to Article 22 and we can use this as an answer. And then in the public and private it can be used in both. So what is mandamus? We command issued by the court to a public official when this public official has failed or refused to perform their duties. It can also be issued against any public body, corporation, inferior court, tribunal or government. So writ is what? It cannot be issued against a private individual. So we can write here so that the next time we don't have to look into it so deeply. And then to enforce departmental instruction that does not possess statutory force. This is important. Why? Because to enforce the instruction on departments that does not possess statutory force, this cannot be done. And when the duty is discretionary and not mandatory, then writ of mandamus cannot be issued. And then to enforce a contractual obligation, you cannot issue that against the President of India, definitely cannot, state governors cannot, and against the Chief Justice of the High Court acting in judicial capacity. What is one more thing from which the President of India and the state governor is exempted? We studied in our last video. See, when we were studying Article 14, we studied that the exceptions to equality, the President of India and the Governor of States enjoy the following immunities, that is under Article 361. The exceptions to the right to equality is given to them. So, apart from the mandamus, the President of India cannot even use President of India is exempted from those equalities also. So President of India and the state governors are, you cannot issue a mandamus against them and against the Chief Justice. So mandamus is issued by whom? Mandamus is issued by court to public body, corporation or an inferior court, a tribunal or government for the same purpose. And habeas corpus was issued by the court again. Then is prohibition. It means to forbid. It is issued by a higher court to a lower court. This is by a court, this is by a court, and this is by a high court to a lower court, and to prevent the latter from exceeding its jurisdiction. Okay, so what is this? This is here. The high court, when it said that the territorial jurisdiction is restricted for high court, what do we say? This is prohibition, that if this is my territory, this is your territory, and you have tried to come here, I will issue a writ of prohibition towards you to not mingle into my affairs. I will say, I will prevent you from exceeding your jurisdiction, and thus unlike mandamus that it directs activity. Mandamus is issued when you say that you need to perform the duties. Here you are saying that you don't need to perform the duties that you are doing. So mandamus is to uplift a person, prohibition is to put it down because the person has exceeded its powers. And thus, unlike mandamus, that is, the prohibition directs inactivity. And writ of prohibition can be issued only against judicial and quasi-judicial activities. So, when this was over any of the public, even the government, not just for private. Prohibition is for nobody in the government or legislation or private. It is only in the judicial and quasi-judicial authorities, not available against the administrative, legislative, private individuals or body. So this is for public private both. This restricts private, Mandamus restricts private, and prohibition restricts public and private apart from the judicial from here. When we come to certiorari, see, in literal sense it means to be certified or to be informed. It is again issued by a high court to a lower court or tribunal, either to transfer a case pending or to squash the order of the latter. And why is it issued? On the grounds of excess of the jurisdiction or lack of jurisdiction or error of law. So unlike prohibition, which is only pure preventive, certiorari is both preventive as well as curative. So it can be issued by a higher court to a lower court to either transfer a case. If this is one court, we have issued certiorari to this to transfer a case pending with the latter to itself. Why? Because maybe they haven't been able to put up the result of this case or anything like that, or to squash this order of the latter in a case. So it is issued on the grounds of the excess of jurisdiction or lack of jurisdiction. So this is both preventive as well as curative. This is certiorari. So this and this is same. Why? Because again, no administrative, no legislative. No, this is no legislative, no, not private, but it is yes to administrative. And then we'll see. See, the writ of certiorari could be issued only against judicial, quasi-judicial, and not against administrative authorities. Why did I mention there yes to administrative? Because in 1991, Supreme Court ruled that certiorari can be issued even against administrative authorities affecting rights of individuals. So this can also be an answer if they ask you whether writ of certiorari can be issued against administrative authorities since the start, then it would be a no. Or writ of certiorari cannot be issued against the administrative authorities. It is again wrong because it is issued but it was changed in 1991. And like prohibition, certiorari is also not available against legislative and private. It wouldn't have been for administrative also, but now it is. And then we come last to the type of the writ, that is QuoWarranto. What is happening? By what authority or warrant are you issuing? It is issued by the court again to inquire into the legality of a claim of a person to a public office. Hence, it prevents the illegal usurpation of the public office by a person. This can be issued only in case of a substance public office of a permanent character created by a statute, cannot be issued in case of ministerial office or private. It can be sought by any interested person and not by the aggrieved person. So this is important, that no aggrieved person has to do it. It can be done by any interested person who has been interested in these aggrieved person matters. So it is issued to not to a minister, not to private, but only to the public office. And why? Just to know about the claim of a person, the legal claim of a person to a public office that it has been doing. This is it with the writ, its types and the scope.